Hello, everyone. Thank you for joining us today for our webinar, Watching the Watchers, discussing the implications of Bill 88 on employee monitoring in Ontario. Thank you all for joining us today, and we appreciate your attendance. I'll introduce our speakers momentarily, but well, there we are. First of all, Lisa Stam from SpringLaw, Reid from the Privacy Pro, and myself, Constantine Karbaliotis. Lisa, I'll start with you. If you just give a little bit of background about yourself for our participants.
Sure. So I'm an employment lawyer. I started my own shop in around 2014 and then moved into SpringLaw, the current firm we have now, in 2017. So we've been a virtual only employment law firm since. So we've dealt with a lot of these privacy issues because of every day dealing with data, all digital, all the time, no paper. So we are deeply embedded in all of this. And I'm excited to talk about the employment law angle of all of this.
Thank you. And Lauren.
Sure. My name's Reid, and I'm president of the Privacy Pro, which is a boutique privacy and ethics consulting firm. We work with companies on how to balance their business objectives with their privacy obligations, mainly global companies. We're based in Toronto, and hence our focus on Ontario. We work directly with a number of companies, and we also work with law firms. And so I'm honored to be here with two of my favorite lawyers.
Thank you. And my name is Constantine. I'm with nNovation LLP, a boutique privacy and data protection firm based in Ottawa and Toronto. And we're also virtual and have been from the beginning before it was cool. And as well as you, Lisa. And we focus principally on privacy and data protection and work with law firms from other parts of the world, within Canada, and of course with many private and public sector clients. My background, just as an aside, I'm formerly a privacy officer in two multinationals, as well as having worked with Lauren at a preeminent privacy and software and research company. So we go back a ways. And so without any further ado, let's start with, first of all, the land acknowledgement. And we want to acknowledge that wherever we are, speakers as well as participants, that we live on the territories of many of the peoples in Canada who were here first. And as we're 10 days away from the National Day of Truth and Reconciliation, I think it's worthwhile for us to think about and honor the fact that we have been welcomed to this country. And of course, the next thing we have to say is the legal disclaimer. Of course, this is probably shouldn't need to be said, but it's being said, like many things sometimes are said. This is informational, not legal advice. If you need legal advice, you should consult with a lawyer. If you need consulting advice, you should consult with Lauren. And so with that, we'll get right into the meat of what we want to talk about today. So start with a bit of a background about what Bill 88 is, its implications, which Lisa will speak to from an employment law standpoint, your game plan, which Lauren will speak to in terms of how do you now deal with this operationally, and then hopefully we'll have some time for some questions. And so let's get started. Bill 88 was called the Working for Workers Act 2022 Act, and it amends the Employment Standards Act. So it's got multiple names, so we'll just try and keep it to Bill 88 as that seems to be the easiest way to reference it. It applies to organizations in Ontario employing more than 25 employees. What does it require you to do? By the 11th of October, the day after Thanksgiving, not far away, you must have a written policy that outlines your workplace monitoring, and you have to keep it up to date when changes are made. Next slide, please. So what does it require? It's got to be in writing, so either posted on your firm intranet, you don't have to post it externally, or posted somewhere where it's going to come to the attention of your staff, where you would normally potentially produce such documents. And it has to define the purposes for which employees are monitored. So it has to apply to either general or specific monitoring, and also has to tell employees whether their devices are being monitored. Yes, next. So nuances. So this applies to organizations that have 25 or more employees on January of any particular year. For as of this year, for future years, employers having 25 or more employees on the January 1st of any year have to have a policy in place by March 1st. But of course, given that we're more than halfway through this year, you have to have it posted by October 11th. Employees include probationary employees, trainees, officers of the corporation, and includes employees who may be on layoff or leave as long as they are still employed by the organization. And you have to include all Ontario locations, as well as temporary staff. Part-time and casual people do count. They are each count as one, not as some proportion. So just be clear about that. And it also encompasses temporary staff. Now, it doesn't include them in your initial assessment of number, but where you are making notice or providing a policy for your employees, you have to include assignment employees, and notice must include their roles, if they're in any way different from what your other staff are doing. Additionally, staffing agencies also have to provide a notice if they exceed 25 employees. So there's potentially, in the case of assignment employees, 2 notices that may actually apply to them, one from the staffing agency and one from where they may be on assignment. Next. So what does the policy have to say? It has to say you may be electronically monitoring employees, the circumstances of the monitoring, all forms of electronic monitoring, and if no monitoring is done, this is important, you have to have a policy that says you're not doing this. So you actually have to say in the negative, if you're not doing any monitoring of employees, we don't monitor electronically our employees. You have to provide the date the policy was prepared and when any changes have been made. Next. So I'll turn it over now to Lisa to discuss the implications of what Bill 88 represents from an employment standpoint.
Okay, thank you very much, Constantine. And thank you to Lauren for pulling this together and bringing us in to work with you on this, because you are the tactical guru on privacy, so it's fun to work with you. So this is an amendment to the Employment Standards Act. So employers are asking us about this, and I think, Constantine, you had said, people in the privacy world may not have caught this necessarily because it's an ESA amendment. So we've been talking about it as just another policy, yet another policy you have to roll out this year. But it really has this nexus with privacy law and then tactically what you do. So there's lots of nuances to this, as Constantine said. It's not limited to just the devices that you're providing to your employees. And now that, post-pandemic, as the dust is settling and we're all working through remote, hybrid, in-person, and what that looks like, very few workplaces are 100% in person, unless the nature of the services, daycares, hospitals, that kind of thing. But even that, some employees are remote, right? Like the bookkeeper might be remote, or some of the admin staff might be remote. And so there is still this, that BYOB trend we had about a decade ago. It's kind of popping its head up again because we're having to revisit. If people are staying home, there's going to be more data and stuff on personal devices, likely, because it's so easy to do it. So the application of this bill, you have to disclose what electronic monitoring you're doing of your employees. And it's very broad. It could potentially be very broad. So GPS, geolocation type technology, CTV, performance monitoring, electronic communications. And Lauren will get into details about just how much we probably don't realize that we are all collecting on our employees. And she'll go through that when we get to the a later section. But if we can just move to the next slide. So the consequences, I mean, do we really have to care about this bill is always a good starting point, especially for tapped employers who are already full and are at their bandwidth of all the stuff they need to do. So what are the consequences of this bill? It's an ESA amendment. So in the same way that if you fail to pay wages to your employee, or you terminate but don't give them their ESA minimums, this failure to provide this policy falls in that same kind of category. Now, the key distinction here is that, does it allow for employees to have a remedy? So can they file a claim against an employer for monitoring them, right? That's probably how many people will hope that they can use this as a tool as on the employee side. But no, the requirement under the ESA is that you provide a policy that that you roll out a policy that discloses what monitoring is happening. And so the thing you have to do as an employer is state what monitoring you're doing. So you have to state this out in a policy. The policy can kind of suck otherwise. There's no like quality control over this other than you need to disclose the stuff that you're doing. And that's the huge job right there. And that's, so the thing you have to do is make the policy. An employee therefore can file a complaint under the Ministry of Labor that you have failed to create a policy. Now, we have zero commentary on this. We have zero case law on this. So we have yet to see it all figured out. I suspect the pain point will be, have you created a policy that actually covers all the different little corners, and now you want to rely on this other little corner that you forgot to put in the policy? Unions will go nuts over that and say, no, you can't fire or discipline this person because you didn't put it in the policy that you're supposed to under the ESA. So there's going to be probably more activity on this bill than many other, like even something like Castle, which kind of didn't have a ton of traction with for day-to-day employers. But I think this one is going to have a greater impact that we have yet to figure out. So does this have implications outside of the Employment Standards Act? Constantine, do you want to field that one? I mean, you're the privacy guy here.
Well, I think that there is potential implications. You've already raised the possibility, may not be able to rely on evidence that may be collected, against, if you want to use it for discipline purposes, because you haven't disclosed it. Mm-hmm. So there's that. There was the question I was going to come back to you with, but there is also the potential, of course, that it will set some standards that it will. That's the whole point, of course, the Employment Standards Act, as to how employees should be treated. And it raises potentially the expectations maybe under the common law. So while we may not see a remedy directly under the Employment Standards Act, it may, again, influence what is appropriate monitoring and, in the workplace. And we do have case law at the federal level under PIPEDA. One of the sad things is, of course, we don't have privacy legislation that covers the employee in Ontario, which is why this is so fascinating, is that it's snuck into the Employment Standards Act as a privacy requirement, right? At least a notice requirement. And I think one of the other conversations we're going to have with employees, when you actually have to disclose this stuff, and Lauren will probably expound on this a little bit because she's talked about it with us offline. Maybe when you tell people actually what you're doing, maybe that's not going to be such a good look. So I do think it has implications. I was going to ask you, Lisa, and not being focused as you are in employment law, if a complaint is made, for instance, for non-payment of, say, wages or vacation, does that lead to an investigation? Does it open the door potentially to a broader set of questions? Because I think that's the concern for small businesses.
Absolutely. And the thing is, it's a cheap remedy for employees to pursue. It's a phone call to the Ministry of Labor, and a labor officer will do the investigation. Now, the only thing you can get out of that is remedies that are as set out in the ESA. So you don't get access to common law damages, for example. But if your whole complaint is like on the wage front, if your whole complaint is that an employer failed to pay you, and that's the thing you're after, a complaint to the ministry is going to be way more cost effective for you than trying to sue them with lawyer fees and everything else on the hook there, because the officer will take care of it. Lauren, if we can go to the next slide, because I think that will continue to expand on where this starts to bump up against whether we want to gather all these things and what qualitatively these policies should be looking like. So on the employment law front, really one of the biggest questions around gathering the data and the reason why I think many employers start to get or the way in which employers get in trouble is when they start hoping to rely on the data that's being gathered to discipline employees. Now, if it's to monitor, and I know I'll share a little further that when you can and when you can't, or when you're likely to be able to rely on data. But if you're simply trying to gather information on your employees, you know, like if you've got some remote employees and you're gathering keystrokes to see if they're malingering all day long and you know, time theft, and you want to be able to catch them. And, you know, some employers would love to not tell them that they're doing all this so they can really catch them. All of that is where employers really run into problems on the privacy employment law front. So, you know, can you rely on the data that you're gathering for disciplining employees? So some of the key principles that we always hear through all of the privacy case law and legislation and principles is a purpose of collecting this data. Is it for the purposes of discipline? And if it is, are you actually capturing that? We definitely see this in the unionized workplaces where CBAs, it's bargained, right? So that it tends to be pretty clearly set out in the CBA and tested by unions, fought back. It's not like an employer who kind of rolls out a policy in a non-unionized workplace and is not really tested until you try and fire someone based on something that you probably shouldn't have gathered in the first place. So it's a little bit of reverse engineering all the time, but in a unionized workplace, it's often figured out ahead of time. So you know, we tend to get a lot of guidance from arbitral case law, even though that doesn't apply to non-unionized workplaces, but some of the analysis and the principles set out there can be pretty helpful. So does a collective bargaining agreement permit it if it's unionized, if you're in a unionized workplace? And then probably more than anything, what formal notice requirements are in place that allow for you to discipline? So are you giving people the heads up that you've got a camera hanging up, or you're doing keystroke notifications, or all the other many layers that we don't understand that we're actually gathering data with? But even some of those basic ones, like when they're swiping in their card in the front door, you know, are employees aware that if they do it late every day, that could lead to some sort of discipline? So I'll talk a bit more about that in a moment, but should you rely on this data gathered will be, you know, really the big soul searching question employers need to really think through as they're forced to articulate what they're gathering. Do we have the bandwidth? Do we want to? You know, do you even know what you're gathering? And then should you rely on it? And that's an HR business decision.
One more thing I would add to the mix, and this comes from case law that under PIPEDA, some of you may be familiar with the Eastman case, which articulated what is reasonable and appropriate, what a fine Canadian way to describe, you know, how we should really think about things. Is it effective? Some of the monitoring that may be done, you may well ask, is that actually measuring productivity effectively? And so that's going to be another element, I think, in the question, should you rely on the data gathered? Because maybe it's not reliable.
Yeah.
And that's, again, something, you know, example that was actually in the media of someone who, if they didn't move their mouse sufficiently during a Teams call, they were deemed as not being present when they were doing all sorts of other things. So is this actually a measure of productivity? So I think that becomes important as we talk about this to think about, is it proportionate? Is it reasonable? Does it actually measure what you think it's going to measure? Yeah. Could there be a less intrusive way to do it is the other, you know, the final sort of part of the Eastman test. And so these considerations, while they've existed for a long time at the federal level, may now have to be something that need to be imported or thought about.
Lauren, can you just flip to the next slide? Because I think Constantine is, there we go. I think this is all kind of related, right? So what are some of the guiding principles when you're figuring out whether or not you can rely on this information to discipline employees or performance manage them? So was the measure that you used to gather that information necessary? Was the measure likely to be effective? And then was the loss of privacy, employee privacy, proportional to the benefit gain, the business benefit? This is a really a tight summary of this. These are elaborate principles to be looking at, but this is the gist of the matter. Was the measure necessary? And really, is there a less intrusive way to gather the information? And in so many situations, don't forget to start with a conversation. Talk to the employee that you're concerned about and say, so how is it going? Like, are you overwhelmed? Are you getting to the things you got to get to? Is there anything going on you want to talk about? Are you getting guidance? Is your manager talking to you? Is there, that less intrusive method on, like, broken telephone is about 80% of my job, right? Of like figuring out, oh, okay, who didn't talk to somebody, and let's talk it out first. But then when you're actually looking at the information, was the measure, necessary, effective, and proportional? Well, Lauren, if you could pop to the next slide. Here's some general guidelines. These are not exhaustive lists, as my little legal disclaimer. These are examples of where you can likely, what is more likely, this is very lawyer of me, I'm not prepared to commit, but more likely that you can rely on data or evidence that you're gathering. I see the data as evidence, right? That's my role by the time I'm touching this. Is this evidence that we can admit as proof that this employee behaved in this way or that way? So these are different throughout the case law. Here are different purposes that tend to be more likely that you can rely on. So is it improving customer service? So every time any one of us calls like a customer service bank line, they give you the warning ahead of time. Is it protecting assets and network security? So is it like a generic purpose as opposed to a narrow targeted person for this individual employee? Is it enhancing employee safety? So if it's like a missing person and you need to jump in quickly and maybe go in to see their last email in order to help, I mean, that's a pretty extreme situation. But if it's a high, if it's a retail storefront and it's high crime, having cameras at the front door is likely to be a reasonable purpose. And if evidence is being gathered on that, you likely can use it. GPS in vehicles, if you're, just tracking efficiency and stolen vehicles. Now the last bullet under this, in an investigation, if you're relying on data to determine a potential breach of law or breach of contract, this is a big rabbit hole that employers could go down, right? That everybody wants the big gotcha moment where they're investigating a harassment complaint, let's say, and they want to start going in through that person's past emails to see all the horrible things they've been saying about everybody to justify the investigation. I don't, that's going to be hard to rely on that if the employee didn't have notice, and if it's not specific to the nature of the complaint in a workplace investigation. And then if it's, but if it's because the concern that you're investigating is that they stole money from the company, then you probably don't have to give them as much notice, and you probably can rely on that evidence because there is we have reasonable grounds to believe there's a breach of law or contract. So there are moments that employers can rely on data that's being gathered with all the different tools that exist, sometimes without notice, but it really needs to be these extreme situations. So where can you likely not just rely on evidence if it's being gathered and you're not telling people, it's to maybe discipline you one day. So if you're just not telling anyone that you're gathering all this private information, or if you fail to disclose all the corners or the purpose isn't aligned. So if it's truly to performance manage your employees and make sure that they're not screwing around all day, you do need to give notice of that. I would word it differently in the policy, but you need to give notice. But the employee's privacy interest will likely outweigh many business interests, especially if there is a less intrusive way to do it, and often there is. If there's no advance notice or no consent given, it's hard to rely on evidence. It really, like, it's very few and only extreme cases. You're way better off to give notice, which I know many employers think, well, then how am I supposed to catch them in the act? The point is to deter them from doing bad stuff, not to like look for criminals. Always look for less intrusive. And if you are working with in a unionized workplace, work with your union big time. All the big unions are very good on this issue because they've had rights baked into their collective agreement for decades now. So there is a big body of case law that will help unions and will be implied into every collective agreement. Okay, I think this is one of my last slides, and then we move on to some of the tactical stuff. HR law risks. So if you try to do all the things, but you don't quite get it right, and you don't quite roll out a policy that complies, and if you breach this provision and you rely on evidence that you shouldn't have gathered, and then you start to act on it. Here's just a collection of some of the things that that could be a legal risk to workplaces. So constructive dismissals all across Canada. Employees can claim that you're targeting them, hunting them down, trying to get them fired, and created a toxic workplace, and so they are now entitled to wrongful dismissal damages. So that's number one. We now have privacy torts in different provinces for intrusion on seclusion and more since 2012 of just privacy claims, including employee against employee, so that there are remedies available beyond just complaining against the employer. I already talked about union workplaces that have always had some remedies. And then in certain provinces, the Privacy Act's not in Ontario. We've got that weird patchwork here that actually excludes employee privacy in most situations. So all the other things will sort of bake around it to set up best practices. And now this ESA section, I think, really is sort of a really important first step into this world for Ontario workplaces. This last bullet is the biggest thing: attrition and business reputation. Like, everybody hates being spied on. So I just, there shouldn't be any ambiguity about that. And there's no evidence that improves morale or productivity. So not sure why employers go there without looking at all the other things they could do first.
I'll just want to touch on that last point. And I think, having been in large environments, one of the challenges, I think, for many organizations, particularly during the pandemic, was not understanding how to measure productivity, except by watching people.
Yeah.
And if we peel back everything, that's really at the heart of this, right? Mm-hmm. And I think it is good that the province has asked, compelling organizations not to change what they're doing, but to be transparent about it. Mm-hmm. Because I think that there is, as you say, a direct impact on morale. We are also talking about the Great Resignation and quiet quitting. These are now elements that need to be considered if you are going to monitor. Can you actually now defend that, explain that in the context of, again, this world that we now are in? So I'll leave that, I think, then for Lauren's now going to jump in. Key takeaways. Sorry, I think this is still yours.
Okay. So, the specific requirements of the bill, Lauren will go into more detail, I think, on that. But if you currently have a policy that is a high level policy that says, well, what many people probably have is, you have, as an employee, you have no expectation of privacy. After our recall, everyone started throwing that into their policies. That ain't going to be enough. You need to start really articulating, these are the ways that we monitor employees. If you are magically one of those employers that don't do any monitoring, you still need to put a policy out that says we don't monitor at all. And so, I think right now it's going to be a big learning curve for all of us to figure out what we're all actually gathering inadvertently and intentionally. you know, and having a discussion with your staff. If you haven't given them notice in the past, talking about why is it reasonable to monitor certain things and start disclosing. And really, I think this is going to really push forward how we manage employees in a modern workplace. You know, the traditional Charles Dixon type of approach of like breathing down their necks and slapping them on the wrist when they don't do enough. It's not motivating, and the generation coming into the workforce now will not put up with it. Quiet quitting is loud and clear, and I think it will continue to push workplaces to really think, okay, how do we align our management practices with how to motivate employees, and simply, you know, throwing in some sort of keyboard, you know, touch type of or keyboard monitoring type of software to see if they're working X number of minutes a day is really going to backfire. Over to you, I think, Lauren.
Okay. If I were better at Zoom, I would take a little poll on how people's heart rate is doing when they realize there's 15 business days.
Another kind of monitoring.
Yeah, exactly.
Monitoring.
Exactly, self-disclosing.
Yeah.
But if you're on this call as a privacy person or as an employee of a company, I'm sure I'm about to raise it a little bit more.
You're supposed to like now help us and make us feel better.
I'm gonna raise it, and then I'm gonna calm you down, because there is a way to handle this. But in the course of researching this, my team, Salome and Victoria, did some work on researching what are some of the top tools that are out there, and wait till I tell you more about them. So I do promise to wrap this up with some actual plans, some concrete action steps. So the first thing is to find out what's actually taking place. You might be surprised what you find out. And so you're going to have to make some decisions about what you're going to do going forward, publish the policy, and then communicate thoughtfully, and be prepared for questions from your employees. And Lisa said this really well a few minutes ago, that, you know, 80% of her job is around people not communicating effectively. So a policy is not effective communication. Publishing this on the bulletin board in the break room or the Slack general channel isn't effective communication. You need to have a conversation about it. So what is monitoring? I'm not going to go all the way through this, but because we did talk about some of it, I want to give you some actual examples. I'm going to show you some of the tools that are used for monitoring. I want to, as a privacy person, I find some of these really offensive. As an employee, I find some of these things offensive. As a business owner, I understand why some of them are necessary. As somebody who came from the financial services world, I understand that you must do these things. I advise companies to use data loss prevention tools. I've worked with some of the big banks on how they monitor their investment advisors' communications to prevent insider trading, for example. So I don't want to imply that all monitoring is bad. I do want to point out that the ones that you thought of when you either saw the posting for the webinar or when we started out, those ones about tracking where the vehicles are, having a GPS on your delivery trucks, that sort of thing. Those ones are pretty well established, and Lisa mentioned, those are some of those areas where you're likely to be able to use the evidence. They've been in place for a very long time. They're quite sophisticated. In a lot of cases, a lot of thought and effort has gone into privacy. Putting privacy controls in place. If you're using systems that are deployed globally, you get to benefit from the fact that they have gone through GDPR compliance reviews, right? And so we get to benefit a little bit from Europe's position on privacy. The productivity, performance are the two areas that, as Constantine mentioned, as we've shifted online in the last 2 years, more and more tools are out there to help people try to recreate what they could do in the office, which is just to walk over and look over your shoulder. I'm going to show you a couple. Okay, so first, these are just some of the logos that we saw. If you just take a second to kind of let those sink in, I bet you all of the organizations on this call are using at least one of them. If you look kind of right in the middle there, Office 365. Office 365 is one of the most widely used business tools. It has monitoring tools built in. Again, it's not inherently bad. Having any of these tools is not inherently bad. This isn't, you know, oh, hey, there's some red flags on the use of HubSpot. 100,000 companies plus use HubSpot for lots of different marketing workflow and automation tools. HubSpot does have features that let you do employee monitoring. So I just want to be clear that there are a lot of tools out there. They are not inherently bad, but they should be looked into. And I'm going to talk a bit about how to go about that, how we've been going about that with our clients over the last several months. All right, this is Geotab. These are just screenshots I pulled from these companies' websites. So you can kind of see that they're looking at, you know, what's the mileage on the fleets. There's lots of reasons they'd want to understand that. We get into top 5 aggressive drivers, like the driver safety scorecard. This is where you start maybe getting a little bit concerned about how that is going to be used, whether it's by management or by HR, or how it might be looked at by the union. These are not necessarily traditionally thought of as employee monitoring tools. The people who implemented this and set it up might have thought that they were monitoring where their trucks were. And so it evolves as well. I'm going to come back to that concept. So this is TerraMind. If you look over on the left-hand side, TerraMind is showing a demo here of how you can tell, you know, the system decides whether the person's productive or unproductive by actually just taking screenshots and screen recordings for 10 seconds of what that employee, Chadwick Singh, was looking at while he was checking his personal email, while he was watching a video on YouTube. This one also, if you go into this demo, you can see that it allows you to drop in and watch instant messaging conversations happening in real time. You can look at everything that he's posting on his social media. You can figure out which social media accounts that are not even necessarily work accounts. This is the most invasive one that I saw. This is the one that had my heart rate rising quite high as a privacy person, and my team members as well. They were like, this is offensive. And I agree. These things are offensive. Gong is another tool. A lot of companies use Gong. It has a really important purpose. It helps sales teams do their job. And so one of the things that Gong allows teams to do is to record calls, and then it uses AI to analyze them. This is not a conversation on data ethics. If it was, we would not have enough time to talk about the issues related to using AI to tell people whether they're good at their job or not. But Gong is a really popular tool. And one of the things that it does is it puts a bot into, say, a Zoom call, and you can name it Constantine, and it records the call because they don't want to be disruptive. They don't want people to know that someone's recording them because maybe they won't be as open. That's a feature you can turn off. And that's what I'm going to get to in a minute when we talk about what to do with these things. The answer is not go delete Gong and do something else or take handwritten notes. That's not our approach to this. And then finally, data loss prevention tools. When you look here, these are really looking at systems and data. You don't really see any personal information here, but it's still an employee monitoring tool because it's still looking at the activity that people are doing. If they're emailing attachments, if they're accessing different, if they're putting USB ports or drives into their ports. So there's, Lisa said, you might be surprised to find out how much monitoring is taking place. So how do you find out? Well, you just ask people respectfully and appreciate that they know what they're doing. This is the key. We don't go into the conversation saying, hey, Legal and privacy are here, and we are going to tell you how to do your job differently, right? That's not the goal. We're here to say, tell me, head of sales, about the types of things that you need in order to get your job done. Tell me a little bit about the recordings that you have to have. Help me understand the tools that you're using, because there's some new rules in place that we've got to be transparent about. So help me understand what you're doing. Having a prepared agenda that they can review ahead of time would be helpful. We all have earned our reputation in this space. I think for any of us who have been around, we can say that as we've grown up in legal or privacy, we've learned how to kind of overcome this idea that privacy is the counsel of no, or that legal is scary. In this case, you're trying to find out some important information that they have a good reason not to give you. So bedside manner is really important going into these conversations, and just appreciate the business perspective. Appreciate that there's a reason why they're doing this. And there's some of these where I can't think of the reason that's appropriate, but maybe there is one, I'm not sure. Appreciate and respect that there's a reluctance to share. And Lisa pointed this out. Your IT security team is not going to spell out for you every single thing that they do in order to detect fraud and data loss. Because if they did, that would be a roadmap to go around it. So there's, how can we still meet our obligations for transparency without asking them to go really, really deep on what monitoring they're doing? Maybe we ask them questions about what type of assessment that they did. And so that conversation is just really important, that you don't come at it without listening. Listening is really important. And then you can help them double check, because if you ask salespeople what kind of employee monitoring they do, they'll probably say, oh, we don't do employee monitoring. That has nothing to do with our job. Our job is to sell product. And all of our employees are aware of Gong in the background recording them, because they go back and they use the recordings. That's not employee monitoring. And they're not wrong. They're saying that because that was not the purpose of buying that tool. That wasn't why they put it in place. So speaking a common language is really important too, and just giving some examples. And so that list of common software tools that I had put up there is something that we've developed as a way to help that person. Hey, look at this list. Do you use any of these? Because just so you know, some of these tools have features in them that are in the definition of employee monitoring. And so we just want to check to see if any of those are taking place. And then the next step is just to talk about, what are you doing and how are we going to communicate it? And the other thing is, don't forget to consider shadow IT. Shadow IT is related to people who are downloading apps that circumvent the procurement process. Sometimes it's because they're inexpensive. They can be deployed as a free trial or with a credit card that's under a limit, right? Some of these tools are $15 a month, but your first month is free. One of them said we can deploy this stealthily in the background in minutes, and you can be looking at up to 3 computer screens within 10 minutes and no one will know about it. That's comforting. That's what we saw with Clearview AI and the police departments. They were going around and giving this as a free trial. It isn't, it happens. It's a known risk. And so consider it. And I think it's important to come in assuming the best from people and assuming good intentions from people, and being really open-minded and working together to find the right solution. Another thing is that I have had this experience multiple times where we do a privacy impact assessment with a client that's considering we want to purchase this tool that does this thing. And we help them. We go all the way through. What does the tool do? How does the data flow? What's happening? What are the risks? How do we mitigate the risks? And we document that. It gets approved. We purchase the tool. Good to go. And then the software vendor just adds a feature in beta. Hey, we added AI sentiment analysis. And now we're going to rate you on how much your customers are paying attention. And nobody bought that. And no one has still bought it or paid for it. It just is there. and in the background. And so those are things why it's important to check up on this right now as you're preparing for this policy. Oh, I love this woman. This is Marie Kondo. So once you've got a list of all of the different monitoring activities that are in place, ask yourself and your HR, IT, operations, security, sales, management, all of the folks who are involved in decision-making about the use of these tools, you could ask them if it sparks joy. If they say no, maybe keep going on the question list. What's the goal or the purpose of this monitoring activity? Again, it might not be monitoring, right? If it's to record calls so that our sales team doesn't have to take notes, or for training and quality purposes, like what gets announced every time, that's what we're talking about here. Is it the least privacy intrusive way to accomplish that goal? Is it working? And how do you know? This is where we go back to that proportionality question. If the monitoring isn't actually effective at detecting the issue that you were trying to prevent, then it doesn't warrant the intrusion on employee privacy. We just saw this with remote proctoring solutions in education. They weren't catching cheaters. They were scanning the whole dorm rooms of students and looking at their keystrokes and monitoring their whole environment, but they weren't actually catching anybody who was cheating. So they, that was not, that wasn't proportional to the invasion of privacy. And then think about the consequences. And I am not a lawyer, but I think a lot about consequences outside of legal consequences, and I call them natural consequences because they just happen regardless of what the law says. And they would be happening today. They'll happen on October 11th, and they happened years ago. If you do things that offend people, they will be unhappy with you. That's how life works too. How are your employees going to feel about this? If they find out that that somebody was able to look at their mouse idle time to judge whether they were productive, how are they going to feel if they didn't know that already? And this one I think is very interesting from a privacy standpoint. Constantine pointed out that in Ontario, we don't have employee privacy laws, but in BC and Alberta and Quebec, they do. And not many organizations are doing one thing in Ontario and different things in those provinces when it comes to these tools. They're generally deployed nationally, if not internationally. So if you publish a policy explaining to your Ontario employees, these are monitoring activities that are taking place, and your BC employees ask rightfully, hey, are you also doing that here? BC employees have another layer of recourse, which is the privacy commissioner, who's known for being quite protective when it comes to employees, due especially to that power imbalance. And so if you go and look at some of the ways that the BC privacy commissioner has reacted to employees' privacy being violated, that would be something to have on your radar if you are in multiple provinces. And finally, how does this look on TikTok? That's what you should be thinking about as well. Lisa talked about generational differences and expectations of employees. There's quiet quitting. I'm on TikTok. I know.
Okay,
I love
going.
TikTok. I don't need your judgment.
I am too, and our firm is
okay. Good,
it's
thank you. It's an informed decision that I take about privacy risk every day.
It's true. It is waiving a few things. That's true.
And it sucks it sucks the energy and life out of me, but it makes me really happy too. And on TikTok, you can see all these. It reminds me of Kevin in Home Alone when he takes the fan and he makes the people dance in the window to make the burglars think that there's somebody home. People are doing this with their fans on their mouse so that their mouse is moving.
Yes.
And
you
this
can get
is
software. You can get software that
go.
will auto jiggle your mouse.
Yeah, somebody was tying it to their cat. Like they were like giving their cat some kind of toy, and then like cat was like dragging the mouse around. So if you think about these tools and taking, for example, the TerraMind one that you can go and look as a free demo. You don't even have to register for it. You look and see that you can just click on any employee's computer screen and see what they're doing right now. Or you can go back to what they were doing at nighttime, because it captures it 24 hours a day. And imagine the clout that someone's going to get on TikTok for posting that. Have you guys ever heard of Edward Snowden? I don't know if that name rings a bell. I think this should be a huge concern for people, because the other thing is that the people whose job it is to do that kind of that task of doing that monitoring does not tend to be executives. It tends to be people who are in frontline positions that may have a lot of turnover, that may have very little loyalty to the company that they also know is doing this kind of monitoring. So I think these natural consequences are extremely important, and they should be something that people are ready for, the questions, when they start publishing them. And so I'll end on deciding what to do, because you always have options. As a privacy person, I like option one, which is just don't do that monitoring. It's data minimization, right? Just don't do monitoring you don't need to do. And that doesn't say don't do all monitoring, but when it's things that maybe aren't working, limiting collection, adjusting the settings, those are probably the easiest and cheapest ways to do this. If you choose that approach, option one, brag about it, meaning put it in your policy, because Constantine explained earlier, you have to have a policy either way, even if it says you're not doing any monitoring. Option number two is keep doing it. You've gone through, you've answered these questions for yourself. What's the goal? Is it the least privacy intrusive way? Is it working? How do you know that it's working? And you've said, yeah, this is a legit thing that I need to be doing. So publish a policy. And that we spent the whole first part talking about that policy, and it's something that we're all happy to help with. And the third option, which is always an option when it comes to compliance, is to just keep doing it and not tell anyone. Not following the law, not meeting the requirement is always an option. And sometimes it makes sense. There's no judgment here. The key is that you understand what that risk is and decide whether you can accept it, whether it makes sense for your business right now. We're not here to preach or we're here to advise, and we'll advise people to comply with the law. But we can also help you understand exactly what that risk is and whether you decide that that's for you to take.
Lauren, there's a couple of questions, just it's related to that, or I think this is a good moment in that slide. But two questions, I'll synthesize them. Basically, what's that distinction between actively or monitoring an employee and it just happening? Yes, we have to disclose it, but is it monitoring if we're not using it to monitor and it's just being gathered in the background? Is it monitoring? I think that's the nature of both the questions that came in.
I love that question. Let me say, that's the question you should be asking when you decide whether it's working. If you have a whole bunch of data and no one's using it, maybe why do you need it? But one of the things that you do have to outline in the policy is under what circumstances would we pull that data? And this is where I think when we look at IT logs and system logs and things like that, if no one's ever pulled CCTV footage, if no one's ever looked at a log, we question, why do you really need to have it? But the key thing here is we might say, we're only going to pull that if someone accuses you of something. That's effective communication, right? That is one of the requirements, is that you outline under what circumstances that you would use it. And
that is a very, very good response from a privacy standpoint to say it's exception based. We don't look at your web browsing unless it triggers there's an inappropriate website. I've implemented DLP in Europe, God help me, where I had to deal with works councils, and that's tough. We implemented DLP, we said, we're not looking at all of your emails. We couldn't possibly be interested or see all of it. But when source code goes out, then we're gonna know that it's exception based. So there's not really, in my view, a difference between active and passive monitoring. It's what is the trigger for actually looking at potentially the data that you're collecting. And if it's exception-based, that I think is a good approach. You also need to think about the retention associated with it, because if nothing has been triggered, then why are you hanging on to it beyond a certain point? I mean, you have to be able to support investigations, IT security, that sort of thing, but you've got to think logically. And this goes to the first question, which was any best practices to address this. There is, it's called a privacy impact assessment, or PIA. And it is an amazing tool that privacy people love, and I particularly like, and I know Lauren does too. Now, in the best scenario, you've done a PIA before you implemented, of course, any of these technologies, right? Because PIA is designed to avoid sleepwalking into risk. And that, I think, is the best way to describe that best practice. Before you actually have implemented the technology, you've thought through what the risks are. You've actually assessed, is it reasonable, appropriate, proportionate? Could we do it in a less intrusive way? Right now, you've got to just tell people right now what's going on. But going back, when you start having the conversations that Lauren's talked about, when you start thinking about the consequences Lisa's talked about, maybe it's time to start putting in place that PIA program, if you haven't already.
Yeah, but then back to Bill 88, what is Bill 88 specifically requiring, right? It's requiring an employer to roll out a policy that to disclose when you're monitoring an employee. Yes. And we have yet to hear commentary or any further elaboration through case law or whatever. So I don't know the answer yet. Does that mean any potentially monitoring software, or does it mean only if you're actively using something? And I'm guessing it'll be something near the middle of that, but I don't know that we know the actual answer yet.
I would say so I think there's always, like, you could go so far to say that, like, the fact that you get locked out of your password after 5 times, that could monitor something. Like, you could go really far. It's a balancing act, and I think reasonableness is the key. We're just about out of time on this. We obviously love talking about this, and we have some ideas on how you can go about these things. Lisa, you were going to talk a couple of more steps about what policies are in place, like what you should be doing, and then how we can help as well. And
I'll be quick. Sync it up with your other policies is the key thing. This idea of monitoring employees is not out of the blue. So make sure that you're taking a quick look at your other policies and sync it up so there's no inconsistencies. The next one is around. I don't know.
We talked about this quite a bit, is just don't surprise people with a policy, just talk to them. And then how can you do this? Well, here's how we can help. We have decided the best way to describe our team as we've been going is it's really a SWAT team. It's taking experts in these important areas that have now all converged. That all should have a very long time ago, but this is a really great opportunity to look at this through multiple lenses. And so Constantine, Lisa, and myself and our teams will meet with you to understand these. What exactly are we working with here? How should we go about it? We do have a template that we will help you to customize after doing discovery, after finding out the answer to that question, what monitoring is in place. So I mentioned that we have a database of the most common monitoring tools and features that will help you go through them, and maybe it's running it against your procurement department. So that might be a faster way to do it. Where's the money going? Who are you spending money with? Because that might be a really fast way to figure out, who authorized that purchase. You're in a large organization and it's difficult to figure out. We don't have time. There's 15 business days. And so it's not a matter of people withholding information. It's a matter of it being, September, lots of vacation schedules and stuff. So we can help you do this very quickly by going at it with these tools and suggestions for how to have these conversations pre-interview questionnaires that are not just asking people to, hey, what monitoring are you doing? But guiding them on how to find that out, because as somebody in the comments pointed out, they don't consider it monitoring. The sales team is not being disingenuous when they say we don't do employee monitoring. That's not their job. That's not what they're doing. They're doing sales. These tools happen to fit that category. And so what we can do is to help each other, really. And then, so we'll bring to you these accelerators and then a summary of what we found. What are some of the issues and recommendations? That might include something like, hey, you know, if you're going to keep using this one, you're probably going to want to think about the justification for it. And we might want to dig a little deeper on what you're collecting and whether you can use it or that sort of thing. Hey, did you know that this tool is deploying something in the background? But what you'll get is a view, you'll get all of our perspectives together on, first, how do we meet this very immediate need of October 11th needing to have a policy? And then on an ongoing basis, okay, what are we doing here? Do we have any risks that we just discovered that we weren't aware of? Because you have to publish it once, but you also have to keep updating it as things change, right? It's not like a one-time thing. Nothing really is in theory, but that communication piece is also really important. We've all been doing this for a really long time. I've seen this go very badly, personally. When people like find out about something, or they feel duped, they feel betrayed. And so we can help you with that communication piece as well, because we've had a lot of experience in that area. So there's all of our emails. Everybody made it onto this call. Thank you for joining us on this call. Thank you, Constantine and Lisa, for joining on this call. And so you can email any of us. You can respond on LinkedIn. You can find a way to reach out. We're happy to tell you more about how we can help and what are some of those tools and accelerators that we have available. If you'd like to have a copy of the slides or a copy of the recording, just email any one of us. We're all best friends and we all coordinate very well. And so you don't have to just pick one of us, but we'll keep it simple for you. So thank you again for joining us.
Thank you, everybody.
Thanks.